Thanks for turning out, you guys. We're going to go ahead and get started. I appreciate you all being here. I'm Professor Bobby Chesney from the School of Law and from the Strauss Center as well. And this is a Strauss Center event. The Strauss Center is one of the things I most love about being here at UT. When I came last year, it was one of the biggest draws for it because it's an interdisciplinary institution in a campus where it has great strengths in that regard. The School of Law, the College of Liberal Arts, the LBJ School of Public Policy. It brings together those of us across these units who share an interest in security studies, and it's an incredibly rich and rewarding experience. Tonight we're going to be focused a little bit on the law side, but we should always, of course, remember that we're never really talking just about law, especially in this realm. It's about law and policy and the tight integration of the two. Professor Clive Walker is with us tonight from the University of Leeds, and I'm going to share a few thoughts about his background here. But before we begin, I just want to note that I've had the pleasure of hearing Clive speak at many a conference and event over the past several years. It seems like whenever there's an occasion in which someone needs an authoritative voice about the British approach to counterterrorism law and policy, Clive is the go-to person. And in all the occasions I've had to read his work and to see him speak, he has absolutely lived up to that standard. About his background, he took his bachelor's from the University of Leeds in '75 and then proceeded on to a PhD at the University of Manchester. And I want to point out two things about this, especially for students in the room. While he was getting his PhD, he was also a law professor, teaching on the side as his day job or his night job, as it were. And notwithstanding that, or perhaps because of that, his dissertation ended up weighing in at approximately, was it 450,000 words? Mm-hmm. Yes. There were no word limits unwisely imposed by that committee, but I think they instituted a rule after that. Oh, yeah. Every word well worth reading. He practiced for some time thereafter, but went on to returned to Leeds to become a lecturer in law and then senior lecturer before, in 1993, becoming professor of criminal justice studies. Beyond all of that, he's gone on to serve as the effective dean of the law school, as we would recognize it here. And in the meantime has found occasion to travel the world as a visiting professor, much to my admiration. I can only aspire to some of these things. And on the side, a fair bit of writing. I wouldn't begin to try to list even the highlights of it all. Let me hit the highlights of the highlights. Early on, at a time when not that many people, especially in the legal academic domain, were writing about terrorism, Professor Walker was writing trenchantly about the problem of terrorism associated with the Irish situation and the Troubles. The prevention of terrorism in British law, to cite one example, in 1986, any number of books, chapters, and articles beyond that. And then since the 9/11 period began, if you want to think of it that way, a steady stream of books and articles and chapters chronicling the evolution of British counterterrorism law and policy, including a series of books for Oxford University Press that are the go-to sources whenever you have questions in this area. I have several of them on my shelf, and I think if you don't, you should. We're going to hear from him tonight on an important theme, and it's coming at a very good time in American policy development. We are, as everyone knows, in the opening year of a new administration in which there is an interest in charting a new course in our counterterrorism law and policy in the United States, including a course that will be perceived and be more widely recognized as consistent with and supported by rule of law values. As part of the debate about how best to chart that course, there's an ongoing dialogue in our country about the proper role of criminal prosecution as a mode of counterterrorism. What are the capacities of the criminal justice system? What are the merits and demerits? We are not the first country to have debates such as this. We're hardly we're discovering it only in our own minds. It's a topic that's been it's a field that's been well plowed in other jurisdictions, and we're going to hear tonight about the British experience. And I think the way you ought to think about it, if you're wondering what this means for the American experience, is to what extent can you translate these lessons into our own particular problem. And without further ado from me, I'll turn it over to Clive, and who will speak for approximately 45, 50 minutes or so, and then we'll have Q&A. Thank you very much for being here.
Thank you. Okay, well, thank you all for being here this evening. I'd like to thank Bobby, Professor Chesney, for his invitation to come to this event, and also thank the University of Texas Law School and also the Strauss Center. Bobby had some very kind words for me. I'd like to have some kind words for him too. I've followed his career around, and we keep bumping into each other in conferences where I stand in admiration at his ability to analyse and explain what to me is difficult law written, of course, in a language which I don't understand, which is American. And I struggle with both the language and the concepts at times, but Bobby's high scholarship has helped me greatly, and I'm sure you should be think yourself very fortunate to have recruited such a stellar academic who will stand you in good stead. It's great. I should say I visit the States quite a lot, and quite a lot of the time I go to Washington, D.C. So being in Austin, it's great to be in a city that the British haven't burnt down, and I hope that my reception is all the much more warmer for not being your sworn enemy. I'm not aware of any plots to invade Texas, but these days, of course, you can never be entirely sure. Let me tell you what I'm going to talk about this evening. As Bobby says, there's a lot that I might cover, but I want to try and stick to the point. And my point is to examine how criminal justice has, you might say, vied with executive measures to deal with terrorism in the United Kingdom. And my thesis, I like to have the thesis, is that criminal justice has, I think, prospered in Britain in the last 4 or 5 years for reasons related to its own advantages and the disadvantages of executive measures. Literally, the result is to put terrorism or terrorists on trial through criminal prosecutions, but to show that whilst these prosecutions can be effective, and some of the faint hearts in America should really take some lessons from the abilities to prosecute people who are equally the worst of a very bad lot that you might have in these parts too. But that also, and suggested in my title, that criminal justice is also on trial. It's in trial to deliver the results that the people and the government expect in terms of securing public safety. And I think it's also on trial in trying to achieve that in a way which does not undermine its own legitimacy. It's a trial of normative values within the criminal justice system, as well as a trial of those suspects who are called terrorists before the criminal justice system. And so there's been a long process which has been going on in the UK, and as Bobby says, I hope this experience might be viewed as valuable to the United States, because we have moved from a system which put a much greater store by executive methods of disposal, or I think I would tend to call it warehousing of terrorist suspects, as I don't think they were finally disposed of at all. They were warehoused, and that was found to be very unsatisfactory in very many respects, and a move then towards criminal prosecution resulted. Let me give you some of the background to the strategy that is being pursued against terrorism in Britain. There's an important document produced by the Home Office called Countering International Terrorism. It has a number of strands to it. If you take a global approach to terrorism, what do you need to do? What do you need to think about? And I think this is a very valuable document. It includes a number of strands beyond what lawyers often think of. It includes strands such as prevent, which is to avoid what is often referred to as radicalisation nowadays, but also includes executive measures of warehousing, as I described it previously. It includes what the British would call pursuit, which I think a prime part of which is prosecution. Pursuing to the ends of the earth, I think, is the full title of this, but our ability in Britain to quite reach the ends of the earth aren't quite what they were when half the world was coloured red, but I'm sure you can assume the mantle of imperialism throughout the world. We have ideas about protect, which are about physical security matters, and preparations, which are really planning for physical security or other forms of protection. Just to break that down a little bit more and to bring it back to criminal justice or to executive measures, I think you can look at the the strategies working out in the following ways. You can see pursuit as perhaps working out either in terms of what you might call traditional prosecution, that after all you can depict terrorism as a crime, and many traditional crimes apply to terrorism. Murder and criminal damage used to be two of the most frequent serious crimes applied to IRA activists in both Northern Ireland and Britain. Sorry, I've moved that on. So we have traditional prosecution, and then you have, and to some extent this is the core of what I'm going to talk about today, we have adapted prosecution. Prosecution is not static, it moves all the time, and if you are presented with specific problems such as terrorism, there may be other problems, but let's take the example of terrorism. It raises specific issues, it produces specific adaptations. The same, I should add, speaking as the Professor of Criminal Justice, might apply, say, to drug offenders or to serious criminal sexual offences or to domestic violence or even to traffic offences. And we have a whole series of special subsets of the criminal law and criminal process dealing with these different problems. As well as pursuit, we have prevent, and again we have different ways of pursuing prevent. They can be, and I've categorised them here as either executive or military, and I think both of our countries use both of these techniques, although in the case of Britain, the military techniques are very much firmly outside the jurisdiction, and there is no claim of a war on terror that the British government use either rhetorically or otherwise. Insofar as there is military use, it is in the specific categories, what they now call, I think, much more insurgency rather than a war on terror, either in Iraq or in Afghanistan. Taking up these choices, it was, of course, one of President Bush's important statements around the war on terror, that it is not enough to serve our enemies with legal papers. There has to be a much wider agenda, which led us into a concept which turned out to be much more than rhetoric of the war on terror, with some of the consequences you see in the pictures. The most, you might say, notorious consequence in terms of the detention of the unlawful combatants in a war on terror. And I can tell you that the British perception of that conceptualisation, that approach, was somewhat critical, that it is seen as inappropriate, as giving status to people who we think should be depicted as criminals or terrorists, and is seen as disproportionate in engaging the military on a wide front. And ultimately, of course, as perhaps depicted by this cartoon, is seen as ultimately rather unsuccessful and not an experience that I suspect either jurisdiction particularly thinks was fondly engaged in. I hope that doesn't offend anybody. I visited Houston, I should add, and I wouldn't dream of showing this in Houston, but I'm hoping that Austin is a different world. I hope. Now, what I've got to say is that actually there was some resonances of this idea of war on terror, not in terms of military approaches of prevent, but in terms of executive approaches of prevent, which followed the 9/11 attacks. And I should add that the 9/11 attacks did have a major impact in the United Kingdom. You may recall, or you may not, that the nationality which suffered the second most number of fatal casualties was Britain. Obviously the American casualties were much greater, but there were a large number of British casualties in the Twin Towers, and so it was seen as almost as much an attack on Britain as it was on the United States, and had major impact in terms of policy shift. So I present this, as you can see, in terms of a dialectic between what I call Belmarsh, and you have to know for these purposes that Belmarsh is the name of a prison in southeast London, where most of the suspected terrorists who weren't convicted but were then detained without trial, they ended up in Belmarsh. So Belmarsh is my depiction, my code for executive measures. And Belmarsh came to the fore. I'm sure you've heard of the Old Bailey, the court of, one of the high courts of criminal court of prosecutions in London, where very usually often serious, what you might call state trials are held. And my point is that the terrorists ended up in Belmarsh, not in the Old Bailey, in the immediate aftermath of 9/11, and that we had the growth of executive orders and to some extent the suppression of court prosecution. And these executive orders have taken two forms. They arise through, first of all, detention without trial, which I've mentioned, which results in people ending up for, as you can see, around about 4 years in Belmarsh prison. This is a normal prison, and the population is mainly just ordinary criminals, convicted criminals in the main, nothing to do with terrorism. And that's where we started. So we enacted a system of detention without trial. And then, for reasons which I'll briefly explain, this was superseded in terms of executive measures by a system called control orders, which I'll say a little bit about in a minute. Now, what I'm claiming, what my thesis is that we've had an interplay between these two, and as I say, immediately after 9/11, one has a surge in executive orders. But I think over time, and particularly after 2005, the criminal prosecution side fights back and regains ground and becomes much more predominant than was the case in the immediate aftermath of 9/11. So that's my claim. What evidence do I have for that claim? And let me put forward some evidence. I have rhetorical evidence. This is from a politician, so it's probably a lie, but let's suspend our belief, if we may. And this guy actually was before Parliament last week for fiddling his expenses. So not only might he exaggerate in terms of government policy, but he certainly exaggerates in terms of his expenses. He had to apologise to Parliament for claiming mortgage expenses that he didn't actually have to pay. A fellow called Tony McNulty, and leaving aside his mortgage claims, his claim, which I think has been underlined by various government ministers, is that it is prosecution which is the preferred approach when dealing with suspected terrorists. And this is a form of rhetoric which I'm claiming has been resurrected, has been emphasised after around about 2005. I can find a number of statements by government ministers along these lines. I should add, in fairness to the government, although it pains me to be fair to the government, I would have to say, is that to some extent this idea of prosecution first has always been there. This was faced very dramatically in Northern Ireland many years ago, when, again, one has a crisis, and the first reaction is to move towards executive powers, detention without trial, and a whole bunch of suspected Republican activists were put in detention camps in 1971, and this was seen almost immediately to be rather a bad idea for all sorts of reasons, was counterproductive, and a judge, a House of Lords judge, was asked to report back on how to effectively reverse this policy as soon as possible, how to revitalise prosecutions. And this produced a report called the Diplock Report, which I think, interestingly, in the times that we are, produced the resurrection of prosecutions. It took about 3 or 4 years to achieve this because the police were completely demoralised and incapable of bringing prosecutions, of collecting evidence and so on. So the police had to be built up before this worked. But it also gives us a signal tale to tell in terms of how criminal trials then became on trial, because to achieve prosecutions we had to suspend jury trials in Northern Ireland. And this raised major issues about whether these trials were legitimate or not, and the battle has been raging ever since. So I'll come back to that point, but we've been down this route before, I think, is what I'm saying. I'm saying that prosecutions have become important since 2005. Just a minute, what counter-evidence is there for this? And it's about yesterday's men, all these pictures, isn't it? Bush and Blair and so on. You remember Tony Blair? He said in 2005, after the bombings in London in July 2005, let no one be in any doubt the rules of the game are changing, by which he signalled a kind of gloves-off approach, that the old ways of criminal justice with these things called human rights, and he paused to spit on the ground at that point. This cannot go on. We cannot afford these niceties to these enemies of the state. A particular irony in the case of Tony Blair, because he had pushed in his administration in the early days to pass a Human Rights Act, which was a major change in British legal culture. So actually, didn't this move things away from what I'm contending? In other words, away back from criminal prosecution to even more executive measures? And my answer to that is no. Like a lot of political statements, look at the deeds, look behind the words. The words are for effect. The words, I think, were to some extent, for reassurance rather than for action. And I think we have to differentiate between what happened to what I call here alien terrorists, people in Britain from overseas, and these are some of the bogeymen of the British government who have caused what the British would see as radicalisation of vulnerable Muslim youth. And these guys are not welcome. There are difficulties in getting rid of them because they come from places like Egypt and Jordan, which certainly have changed the rules of the game and don't believe by abiding by any rules of any game. And this causes issues about non-refoulement. The rendition unto torture would not be legal either under English law or international law. So a number of laws are changed to try and deny asylum, deny nationality, to curtail appeals within the system, which are all these measures. And then we move on to the idea of diplomatic assurances. We begin to engage with the Egyptians and the Jordanians and the Algerians and the Lebanese and the Libyans even, to say, if we take these people back, if we give you them back, will you please behave and not do nasty things to them? And of course they all write and say, yes, of course, no problem. And these cases then come before our courts to say, is this worth the paper it's written on? And the courts, I think, take a case-by-case approach. They look at the particular circumstances. In some cases they've said, no, this is not worth the paper it's written on. And in some cases they've said, well, maybe it is. In fact, not one of these has been deported without their consent as yet. Some of the cases are now before the European Court of Human Rights in Strasbourg. But just to complete my story, what happened to alien terrorists was rather different from what happened to what I've taken to call neighbour terrorists. These are the bombers of 7/7, the suicide bombers of 7/7, who blew themselves up in either London Underground trains or in one case on a bus, a London red bus. And I call them neighbour terrorists because I want to depict them as being internal to Britain, internal to processes and cultures within Britain. They are not aliens. These are not guys who live in caves in Tora Bora and speak different languages. And I particularly call them neighbours, and I put down here their address of Alexandra Grove. This was in Leeds. This was about 300 yards away from my office. They are my neighbours in all senses of the word. They were Leeds residences. They spoke the same language as me. They were brought up the same way, well, to some extent, to a fair extent. And this now, I think, is the model of terrorism threat. It is not the aliens. The aliens have been detected or have been excluded. It is the threat from neighbour terrorism, which I think has also indicated a need to transform our policies. If these are our neighbours, we've got to engage with them. We can't treat them as not worthy of our respect anymore in a way which might be possible has been possible, it would appear, with the aliens. So I think this alien-neighbour dichotomy is important and is a reason why there is an emphasis on criminal prosecution. The more you find your terrorism is from your neighbours, the more you are impelled to criminal prosecution and away from executive measures. Or at least that's been the experience in Britain. So that's my first reason why I say there is a trend towards criminal prosecution. Let me just get back to some of these other reasons, some other indicators. I then look at the content of legislation since 2005 and ask myself, is this about executive measures or is it about criminal prosecution? Before 2005, a lot of the legislation, or round about 2005, a lot of the legislation is about executive measures. After 2005, it is about crime and process and sentencing. And this is true of the two most recent pieces of terrorism legislation in Britain. So we find that the agenda, the legislative agenda, has changed. It has a different focus than was previously the case. My next indicator why I think that criminal prosecution has grown in importance is the fact that there are very few executive orders, that this measure is still on the statute books but has become rarely used. And I look on the one hand at the statements by the people like the head of MI5, the security service, James Bond's boss, you might call him. And if you ask him how many terrorists do you think there are in Britain, he will say that we've got somewhere between 2,000 and 4,000 people under scrutiny. There are degrees of scrutiny and we can't afford to follow them all round every hour of the day, but it's quite a lot of people who are of interest on grounds of suspected terrorism to the security services. How many executive orders? Answer 15. So there's a great mismatch between the threat and the use of executive orders to deal with the threat. And I think in other words, the main emphasis, if you were to ask how many prosecutions per year, well, quite a lot more than that, a steady amount, which I shall now reveal, and it is the statistics for charging and prosecution, which I think tell finally in a rather crude quantitative way this story. Let me just highlight two of these columns. The first, I'm not saying this is dramatic change, I should add, and the numbers are modest in any event, but I think one can see a trend to some extent. And I'm saying, first of all, that convictions tend to increase. The emphasis, the reliance upon convictions tends to increase in the later years, 2005 to 2007. You can see that both the numbers and the proportions of people being arrested resulting in convictions has increased, generally speaking. And in the final column, the highest rate of what I describe as other action, whether it's deportation or some form of executive measure, has tended to decrease. So you find the highest numbers at the early part of this period and not the later part of this period. So I'm not saying this is dramatic, but I think there is evidence there of a trend emerging. We shall see as time goes on. Okay, let me pause for a minute and reflect on where we're going. I claim we have this trend. Let's just pause for a minute. Is this a good trend or a bad trend? The primacy of criminal prosecution. Is it a good trend or a bad trend? And my guess is that most lawyers would almost instinctively, they've been taught well by Professor Chesney, I'm sure, to be ethical lawyers. And they think of criminal prosecution as being good and putting people in Guantanamo bad. Is roughly how we think. Why do we think this? I think there are a number of reasons. Broadly speaking, our criminal process is very formal, relatively open, and all of that adds up to respect for individual autonomy, respect for the individual and their rights. And we see that as generally good. And as far as the system is concerned, it's good because if you can show that you're treating people properly with respect, hopefully it gains legitimacy for the results of the prosecution, and also the system itself is seen as a fair system. It's seen as a system that even the people's community, the people who are being prosecuted, their community can accept that this is a fair result, and that the people from their community have been fairly shown to do wrong. So all of that is good. But then if you ask some of the people in the security business, the boss of MI5 that I mentioned earlier, they will say, well, there are problems here, and some of the problems are criminal prosecution tends to be after the event. We traditionally in criminal law, we wait for the crime to happen and then we start our detection process. We don't want to do that with terrorism. If we have to wait for 3,000 people to be killed, it's too late. We've got to intervene before the event occurs, and traditional criminal prosecution hasn't been too good at that. We have issues about disclosure. Some of our evidence might involve secret means or people whose identities we don't want to disclose. And finally, we have perhaps, contrary to what I've said, system legitimation. The opposite, the idea that the courts are being co-opted by the state into persecuting particular minority communities. And we want to save the courts for cases which have nothing to do with politics, so that we preserve them as, if you like, pristine in terms of their separation of powers, and not run the danger that minority communities will see them as objects of distrust. What sort of conclusions do I reach? Well, basically two from this. That I think both the elements of pursuit and prevent will, of course, persist, and that both of these tactics will be used. Another point I think that could be raised is the which Professor Chesney has certainly spoken very eloquently about, is the convergence between the two systems that one finds, and I'll talk further about this, one finds due process ideas being inserted into executive measures and becoming more like criminal prosecution, and equally one finds criminal prosecution diluted, and that's mainly what I want to talk about, which is due process is applied to both of the elements of the strategy and increasingly over time. My point about increasingly over time is I perceive, both in terms of what happened in Northern Ireland, which happened over a very long time, over 30 years, and what's happened since 9/11, is that one finds judges become, I think, emboldened as they move away from the immediate point of the crisis, and that our arguments about deference tend to decrease as time goes on. That's been seen, I think, very dramatically in Britain for some of the cases which deal both with prosecution, but even more so the cases which deal with the executive measures. So what I want to do now for the rest of my time is look fairly quickly at the both of these areas and talk about how these processes have worked. But I think I'm not just saying convergence. I am saying that these processes give criminal prosecution an edge. But whilst there may be prosecution, the result is a primacy at the end of the day. One does it better than the other and finds it more comfortable to deal with the pressures of due process. It isn't a kind of equal contest. And in many ways that's not surprising. Of course, criminal prosecution has traditionally been set up on the basis of due process, whereas the executive measures find it much more uncomfortable to bring due process within their systems. So let me first of all talk very briefly about the prevent measures, the executive measures. And what I'm going to show here is, I hope, a story which says that the letting due process in the door has confined the executive measures and has given a boost to criminal prosecution. So what I say first of all is there was a fairly unavailing background, a history of judicial deference in the application of executive measures. The phrase non-justiciable was used in a great deal of cases, great many cases in Northern Ireland between, say, 1970, even up to the mid-1990s. The courts were still saying that issues of executive measures were not justiciable in the courts. And there was exploitation of juridical boundaries between criminal and executive. All of these caused problems, but without going too much into the past, what I want to say is that there's been, I think, a very marked emergence of jurisprudence of a jurisprudence of national security has emerged within the UK courts, and this has resulted in really major problems for the application of executive measures. They found it very difficult to deal with this judicial activism in favour of due process, and I'll give you some instances of that. First of all, the measure of detention without trial, which was introduced in 2001, came up against a decision of the House of Lords, what we now call our Supreme Court, starting in October, in a case called A against the Secretary of State for the Home Department. And in this case, the House of Lords, the Supreme Court, basically said that this measure of detention without trial is incompatible with human rights demands for due process, and also for, in particular, they were saying, against discrimination. It was a discriminatory measure because it only applied to aliens, and it was not acceptable to apply your security measures against aliens when at the same time you have this other group of people, who I called neighbour terrorists, who are equally as threatening as the aliens. This is nonsense, the House of Lords said. This is irrational. It is disproportionate to target only the aliens. It makes no sense. And so they said this could not be said to be a rational policy, and the government had to think again. I mentioned on the slide that very recently the European Court of Human Rights has basically agreed with this analysis of the House of Lords. It took it, as it does, bless it, 5 years to reach the Strasbourg Court's decision, but it got there in the end and, as I say, basically agrees. So the government has to rethink, and what it comes out with is something called control orders. These are orders which don't involve people being imprisoned, but subject to obligations, restraints, duties, and surveillance. It may be in their own homes, but probably you and I would call it house arrest, might be a way of putting it. It's not total house arrest. They can go out maybe for 8 hours or 12 hours a day, but they're always going to be under restraints and surveillance as to what they can do. Not allowed to take jobs, not allowed to have a computer, not allowed to have a bank account. If you want to see anybody at home, it has to be cleared by the Home Office. So it's not a comfortable situation. Two questions I have for these control orders. Are they in breach of due process per se? And if not, have the courts ensured due process has actually been granted? And we've had a whole series of cases about this. Is it a breach of due process per se? The answer given again by the House of Lords is no, provided a sufficient amount of disclosure is given to the individual as to the reasons for the control order. That was in a case in 2007. And then, so control orders still exist, and we have a whole series of cases about the standards of due process, how much disclosure of the case to the individual so that they can represent against it has to be given. And we have constant cases going through the courts. The biggest recent case was a case called AF number 3, where the House of Lords came out with a formula that the person under suspicion has to be given sufficient information that they can effectively instruct counsel. That was their test. And they didn't exactly say how much that is. How much is that? Well, it goes back to court for litigation. And so what we've got is a series of cases, and I'll just give you some figures. I counted up that since the case of AF, which was only in, I think it was May this year, AF number 3 was in May this year, we've had a further 6 cases and I counted that the government have won 3, the government have lost 2, and I think I'd call 1 a draw. They live to fight another day. So my impression from this process is there is a lot of litigation, first of all. The government is kept on its toes, is made to feel uncomfortable by the courts. They have to justify themselves at every turn, and they do actually lose a fair number of these cases and either have to say, well, we give up and we're going to rescind the control order, or they have to rewrite the control order, produce a new order, and we go through the dance again and go back before the courts. And this, as I say, is rather uncomfortable. One rather worried-looking Home Secretary government minister says, oh no, these control orders have got holes all through them, he said in 2007. Don't feel any sympathy for these guys, please. And the more recent Home Secretary, who looks equally as concerned, said he was very disappointed at the AF number 3 case. Not that he understood a word of it. He isn't a lawyer. He didn't understand. And again, I have no sympathy with the guy. I'll conclude on these executive orders. And what I'm saying is the courts are pressuring the executive. They aren't saying you can't do it, but they're saying if you do it, you are going to be subject to close scrutiny and quite a lot of litigation. Are you sure you want to go down this route, is the impact. And we end up with no more than 15 orders, despite having 2,000 or 4,000 people who are under serious suspicion. And so I think the courts have done a good job here. They could have said it was unlawful. They could have said that it is contrary to human rights. But I think the way in which they've approached this has been better in terms of producing a dialogue with the executive and ultimately producing what I described as the jurisprudence of national security, which we never had before. So I see this as very productive and very clever on the part of the courts. Okay, there are some other orders, I won't go through these, that we could make to executive orders. Let me turn next and finally to criminal prosecution. I'm saying criminal prosecution is the prime mode of disposal, but this is problematic. It puts criminal trials on trial as well as the terrorists on trial. We've got to have some respect for precautionary logic, the idea that we want to intervene early in the threat cycle. We don't want to wait for the bomb to go off. We've got to be able to intervene earlier, and this demands, I think, changes in traditional criminal justice. I won't go into this. There are costs of imprisonment. We've discovered that, surprisingly, a lot of radicalisation goes on in prison, producing further terrorism, as well as the fact, of course, you imprison somebody for 40 years in a high-security prison, it costs you £50,000, £60,000 a year, and if you have a lot of these people, probably like us, you're bankrupt and you can't afford it. Okay, what are the problems? These are some of the traditional problems of the responses in criminal prosecution. I'll start with criminal offences. What are the techniques for responding to the notion of precautionary logic? You have ideas about net widening is the first way. So you start broadening the concepts of criminal law. For example, we use a term called terrorism in the criminal law, as if that was unproblematic, as if there was a clear definition of what terrorism means. And we just throw this out and say, well, if you're a terrorist, we can prosecute you, without being very clear as to what that actually means. And that's what I mean by net widening. Using terms which have no clear meaning is a way of using precautionary logic. We have guilt by association. We say that if you're a member of, let's say, the Tamil Tigers, this top picture here, then by definition you're a terrorist. Doesn't matter if all you do is wave a flag in front of Big Ben, as in this case. There was a demonstration and quite a lot of people waved a flag in front of Big Ben in May this year and actually didn't get prosecuted, but they did all commit offences under unlawful associations laws in the UK. So we have guilt by association. And then finally we have a concept that you've got to refer here to the great Professor Chesney, who knows all about precursor offences, offences where you are providing what in this country you would call material support. And we also have a wide range of these material support offences. And one of the main effects, of course, is effectively to switch the burden of proof. We find you in these circumstances which could be construed as suspicious in some way and linked to terrorism. Prove there was no link. You prove there was no link. So this is rather different from proving a murder charge where the burden is very much on the prosecution to prove not only you bought the knife and you sharpened it, but you stuck it in and you killed somebody and every stage of the dastardly deed. This is not true of precursor offences. So these are some of the changes that we've made. We've had a whole series of cases which I think my time is short. I can go through these cases, but I would say there are a couple of things to draw from the experience of dealing with these cases, and they are these. One, there has been a reluctance to prosecute, is one of the good things. The police in particular have not used unlawful association membership very frequently at all. So there was a big demonstration for the Tamil Tigers outside the Houses of Parliament, Tamil Tigers being an unlawful association, people waving flags which were unlawful flags and shouting chants which were unlawful chants, and not one of them got prosecuted under these terrorism laws. The police can be really remarkably tolerant when the mood takes them, and I think they can see the concerns about how it would view to lock up large numbers of demonstrators. The other thing is statutory interpretation, and that's really what these cases are about, trying to lower the burden of proof again, trying to say, for example, in some of these cases, well, if you can raise this as an evidence that you had some kind of reasonable excuse or any reason at all for having these materials, then we will shift the burden back onto the prosecutor to prove that there was a link with terrorism. So I think there's those two trends have occurred and have diminished the potential threat of these offences. But having said all of that, rather like the trend in the United States, the precursor offences are the most common offences used in terrorist trials in Britain. So just as Section 2339, I don't know whether it's A, B or C or all of them three together, probably B I would suspect is the commonest. Equally, Section 57 of the Terrorism Act 2000 is the commonest special criminal offence charge in prosecutions in Britain. Okay, let me talk a little bit about criminal prosecution and then I'm done. What pressures does it create? Well, the first pressure is on the jury. I mentioned Diplock before, but which produced non-jury trials. And we still have these in a piece of legislation called the Justice and Security Act 2007. These are not commonly used now because most of the main protagonists in Northern Ireland have declared a ceasefire and have, in some cases, claimed they have disarmed. But we still have a variety of either Republican or Loyalist groups who are still committing acts of political violence in Northern Ireland, and when they do, they come before these non-jury courts. And we have no constitutional reason why we can't have non-jury courts, I'd have to say. And equally, you don't find a lot of support from the European Court of Human Rights. Of course, in Western Europe, the picture is varied, but there are quite a lot of jurisdictions which don't have jury trials. So it is not seen as fundamental to European jurisprudence to have a jury trial in order to achieve due process. The next point I wanted to make is there have been some ideas of removing juries in coroners' cases, but that's getting rather technical, so I'll just skip over that. Let me talk a little bit about procedures. Procedures have been changed, and what I think I would say is that de facto we've moved to a special criminal process for trials. What's happened is that the trials have been centralised under a protocol, and they are all brought within the jurisdiction of what is called the South Eastern Circuit, and particular specialist judges deal with these cases, and they particularly, I would say, micromanage these cases to ensure that nothing untoward or too expensive happens. And I'm still sort of debating whether this is a good idea or not, this centralisation of criminal process. On the one hand, I like the idea that there's being skills brought to bear in these cases, but on the other hand, when I used to spend all my time researching Northern Ireland special criminal processes, we developed, myself and a number of colleagues, a concept called case hardening, which we thought really fitted the bill. In other words, judges who dealt with these cases over and over again, I think there were two phenomena that arose. One is they got very friendly with the repeat players, and the most frequent repeat players are police and prosecutors. These were their friends, basically, and they didn't like to upset each other. And that's too cosy a relationship, I think. It's inevitably going to happen if you don't have a rotation of the judiciary. But I think that went on in Northern Ireland, which is in any event a very small jurisdiction. And case hardening also, I think, referred to the idea that the judges, when they heard the pleas from the defence, it was kind of, well, we've heard all of this before and it turned out not to be true, and we're very doubtful that we should listen to these pleas. So the rates of guilt, the finding of guilt, went sky high. The rates of acquittal went very low. And this is what we mean by case hardening. So I think there are different perspectives, and I think I'm worried that it could result in case hardening. But then again, Britain is not Northern Ireland. Britain is a much bigger country than Northern Ireland and has the capacity to include a lot more judges within a specialism than was the position in Northern Ireland. So I think this is open to debate as to whether it's good or bad. On the other hand, there are things that are bad. These cases tend to be very big cases, and the prosecution resources, particularly on issues like forensic analysis, far outweigh anything the defence can throw in return. So the defence are at a disadvantage. I think the defence are also at a huge disadvantage in terms of media treatment in these cases. Labelling from the start somebody as a terrorist is not helpful if you want to get an acquittal from a jury. So you almost have prejudice built in to these cases. And it is amplified, I think, by politicians who just can't help themselves commenting. We had a case earlier this year in Britain where a group of students in the northwest, students from Pakistan, were arrested as supposedly as suspected terrorists. And the very next day, our esteemed leader, Gordon Brown, talked about the police foiling a very big terrorist plot, is what he said on all of the TV stations. Not one of these guys ended up being prosecuted. But I rather fear if they had, what's the effect of your Prime Minister saying, well, these guys were involved in a very big terrorist plot? It is not helpful. Some of the other trends we face, special restrictions on due process in terms of the use of special advocates, not in the main trial itself, but in some of the pre-trial or post-trial hearings. There is the idea that you might be able to get over the difficulties of non-disclosure of evidence by appointing special counsel for the defence and allowing the special counsel to hear the evidence. We've even had secret judgments. There are a number of judgments which have been heavily redacted, where we know what the result is, but goodness only knows why. And the most extreme case of that was a fellow called Danny Morrison in Northern Ireland, whose the total judgment was redacted. He was acquitted, but who knows why. He got lucky, I guess is all you can say. Okay, we have lots of issues about evidence. Well, I go through these very quickly. I preface this with the point that, of course, evidence law is often nothing to do with the Constitution. And in Britain, we've changed lots of laws about evidence, quite substantial and ages-old evidence law without a by or leave. We've changed rules about the right to silence. In all cases, not just terrorist cases, we've changed a lot of hearsay rules in 2003, in all cases, not just terrorist trials. As far as terrorist trials, we've had a number of problems with public interest immunity. This is going to be a common problem in these cases. We have no particular solution to this. Torture evidence is going to be a problem. We have had a strong judgment of the House of Lords saying that any evidence where there is any reasonable suspicion of torture, not even full proof, is sufficient to have it excluded, although the judges are not so clear about lesser standards like degrading and inhuman treatment. we have a whole bunch of problems about agents and informants and how far the relationships with the state are disclosed in the trials. And then finally, I just wanted to sum this up by talking about one of the biggest case in Britain in recent years, which is Operation Overt. This is a case, if you've ever travelled on an aircraft in the last 3 or 4 years, you know about this case. You can't take your bottles on the aircraft anymore. It's because of these guys in Operation Overt who were arrested in London in August 2006 on the grounds that they were going to take all these little bottles with some form of high explosive in them. And after this point, these little bottles were banned. The case has gone on for 3 years now. And after the first trial, which was, I think, in 2008, the outcome was that there were quite a lot of convictions, but some of the most serious charges of, in other words, the convictions for conspiring to plot terrorism, but the charges specifically related to the airlines were actually not sustained. The juries could not reach a verdict, and this was this guy standing outside the Old Bailey here, the Central Criminal Court, who was the head police officer at the time of anti-terrorism policing. He said this. He sort of complained about the jury failing to sustain strong evidence despite the failing to sustain convictions despite strong evidence. He did go on to say there is no need for military commissions or juryless diplomat courts, such as in Northern Ireland. And I would add, not yet, I think is what he's getting at there. It's interesting that he raised the point, and it was at a stage where a further trial was pending, and that further trial has secured both more convictions but also more decisions by the jury that they couldn't reach a decision, and now there is a third trial pending. And I just wonder, how long is the patience of the executive in these cases? Will they reach a point where they say, well, these juries, they're just not fit for purpose, and they can't be expected to deal with these cases? So I think that's where we stand. I'm going to cut to my conclusions, if I may, because already time has passed. My conclusions are simply these. Sorry, I'm here to sell my book, is the reason for that slide. I'm sponsored by Oxford University Press, so you all have to buy this book. A couple of conclusions, 2 conclusions. The first is that I would welcome the rebalancing in favour of criminal prosecution. I think there has been a rebalancing. I think that is a signal for jurisdictions like the United States that rebalancing is possible. I think the other lesson about rebalancing is it is largely possible within existing normative frameworks, but you can expect to change some of the details of what you're doing, both in terms of criminal offences, which you largely have done, and in terms of evidential laws, and in terms of the administration of process. So I think in Britain you could say we have a de facto special terrorist court in Britain through the consolidation of all of these measures. In Northern Ireland there is still a formal special terrorist court, but in Britain it is de facto. And this is eminently possible, and I quite like the idea of this accretion of changes, because one advantage to the way that we've done it in Britain is that it has allowed lawyers and judges to be major players in how this system has been designed. It hasn't gone to Parliament for an Act of Parliament to design it in the way that diplomat courts are designed, in a rather brutalist fashion. The judges and the lawyers have sort of pushed and pulled between themselves and reached roughly accommodation. So I quite like that process. Having said that, I also am a member of the Lawyers' Club, so perhaps I haven't given you an entirely impartial viewpoint. So we've got, I think, a de facto court which seems to work passively well, and we sustained, as you can see, quite a lot of convictions, and far more convictions than is necessary compared to the executive measures. I just wanted to mention further that whilst I've talked entirely about criminal process and so on, there are other agendas which I think are important. One which I actually think America does far better than Britain is dealing with the victims of terrorism, and British law has said virtually nothing about victims, whereas I think the treatment of victims is much better in the United States. And the other point I wanted to make was going back to some of my early slides about strategy. Lawyers tend to think of prosecutions, that is their lodestone. The court is their lodestone, the court is their home. There's a lot going on outside the courts, and I think in many ways the most important initiatives that have been taken over the last 3 or 4 years, since 7/7, have been about social control, have concentrated on prevent in terms of lowering tensions, lowering the reasons for people taking up political violence, being attracted by political violence, understanding their concerns, understanding their social situations. So just to kind of depict that, I present it as follows. You have criminal justice, which we have a very formal system. We have executive controls. But I think really the broadest strand of policy that we ought to engage in, and I say this particularly because these people are our neighbours. I come back to that concept of neighbour terrorism again. We can't simply say these are alien people we don't understand, we don't want to understand, we just want them to go home. Their home is our home. We have to understand. And my final message then is not about prosecution, not about executive measures, but is about understanding our neighbours. And I think that's the way we actually prevent terrorism. Thank you.
Why don't we do this? I'm going to ask a couple of quick questions, but then let's quickly get to the audience. I want to give everyone else a chance to speak, but I can't resist playing devil's advocate a little bit. I feel it's my responsibility. Hearing of the many, you gave quite a long list of things that have been done by way of changing otherwise traditional norms in terms of how criminal prosecution works, procedurally and substantively. And I'm struck by the prevention-oriented nature. When you're talking about people being prosecuted, at least in theory, although not in that instance for waving flags or chanting, it's part of a larger set of substantive offenses that you and I have both spent a lot of time with that are in the nature of creating grounds for prosecution before harmful acts occur, preventative statutes. Combining that with some of the procedural innovations that maybe are the result of an effort to make it easier to secure the prosecution in these high-stakes types of cases, one could, I think, hear all that and think, well, I don't really like what this is doing to criminal prosecution generally. It results in a de facto security court, as you say. But if that's not formally firewalled off from the ordinary criminal justice system, the next thing you know, the anti-gang prosecutor and the narcotics prosecutor are going to say, the violent crime prosecutors are going to say, I need those same advantages for my system because my victims are just as important. And so one might argue that this is actually a good argument for having a standalone court that's some sort of distinct system altogether from criminal prosecution. And then once you make that move, then you are having to then explain, well, what's wrong with the militarized approach to that? And you can have responses to that, but is it wrong to seek to entirely set off the special court system from criminal law?
I'm not sure it's feasible, I think is my immediate response to set aside a special court, unless you do something very drastic, which I think carries its own many difficulties, like, say, set up a military type system, which is completely separate. But I come back to the idea, I think, that we already have a number of specialisms for different purposes. And I don't see this as indeed wholly distinct. In other words, let's say terrorism creates a set of problems and we respond, just as you might say mafia crime produces a set of problems and we respond. What I see in England, in Britain, is that there are indeed two-way exchanges in these matters. In other words, don't just think of the terrorism provisions, as it were, polluting your pristine criminal justice system, because I think two factors. One is your criminal justice system is not pristine. You've already got these special measures for the mafia and so on. It's already been changed. And also, some of those ideas about, I would say about, for example, drug trafficking, in terms of going after the finances of drug traffickers, have been brought into the terrorism field. So in that sense, it's a two-way thing. But yes, I would concede that we have to pay attention to the concept of proportionality and ask ourselves constantly, why do we need these special measures? My concern, I think, is not about whether this special measure should only apply to terrorism, but what is the foundation for it? What is the feature within terrorism which causes us to feel inadequate in our traditional criminal justice system and to produce some change? And if you can show that this is shared between mafia gangs and terrorist gangs, I'm not sure I'd have any major objection, assuming then I would go on to my next question, which would be, is this special measure consistent with due process? It may be special, but that's not to say it's, in your terms, unconstitutional. Now, some of our measures, of course, are unconstitutional in your terms, and I would readily admit that I think the membership of a terrorist organisation, I'm not sure I could see that getting past the way in which it's constructed, the First Amendment. But then I'm not sure that's very important. In terms of the number of prosecutions for that offence, I don't think since 2001 there have been more than 5 or 10 in Britain. It is quite frequently used in Northern Ireland still, and has been since, I think, about 1918. So we kind of got used to it in Britain. But I think if you take an example like, say, some of these precursor offences, well, to some extent we've got these in drugs laws about the possession of precursor materials in drug offences to produce the drugs are themselves drug offences. So I think my two questions are, number one, can you show there is a proportionality between using this measure and the problem that you face, and can you show that the measure is relevant to the problem that you face, whether it's within terrorism, drugs, traffic, domestic violence, whatever it is. I find it difficult to see that terrorism and domestic violence are going to be linked, but terrorism and drugs have certainly been linked, or terrorism and organised crime has been linked. And secondly, in any event, does this meet your constitutional standards? There we differ somewhat, but I think we can ask basically the same question.
Great. Well, let's get some questions from the audience, and we'll start here on the front row.
Two parts. One, you give very light treatment to the Supreme Court. Is it fair to assume that you believe that the court coming into force right now is not going to tremendously change the dynamic that you described? And the second portion is, to what success has the UK had in using those Article 57 measure, I believe, the measures that come before an actual crime is committed? What, if you could mention this one?
Okay, the Supreme Court is an interesting phenomenon, but I think much more important actually than the Supreme Court was the passage of the Human Rights Act in 1998, which came into force in 2000. Of course, we were not unfamiliar with the concept of human rights. We like to think we taught the world about human rights and go back to Magna Carta 1215, when long before America was a concept in anybody's eyes, with the exception of one or two Danes and the people who lived here already, of course. But I think the Human Rights Act was treated as a signal that the courts had to treat human rights more formally and more seriously than was previously the case. And so you see a burgeoning of human rights litigation after the legislation came into force in late 2000. And I think this then began to apply to the issue of terrorism, as exemplified by the case in 2004, which did indeed come before what is now the Supreme Court. So I think the trend was already there, is what I'm saying, before the Supreme Court came into being. What effect will be the advent of the UK Supreme Court? Well, the opinions are divided about that. First of all, I don't think it will be as big an effect as the Human Rights Act, I would say. Will it have any effect? Well, I don't know. The personnel are the same. The judges are the same in this court. There's not a heap of new judges who are coming in. It's basically the same old judges. So either they were for rights or against rights before. But it is felt that this signal of separation might eventually give a further boost to, shall we call it, judicial confidence that they are now separated from Parliament. They don't meet some of the people they are being nasty about in the corridors anymore. And maybe this encourages them to be even more fearless than they currently are. I think if it does, it'll be a subtle change and it'll be a long-term change rather than anything immediate, because of the fact that they are basically the same people. But I think, in time, as people get appointed to this court, and they see themselves as quite different from the Houses of Parliament, which, of course, in our case, you might think as the legislature, but it's equally the executive. The executive dominates Parliament in our case. And so they were mixing not only with legislators, but they were mixing with ministers of the Crown as well. And the argument is that in time that will have some effect, but I think it will take quite some time. Your other point was about the provision in the Terrorism Act, Section 57, the idea that if I possess, let's say I have in my bag here, which I assure you I don't, I have some wires, I have some batteries, and I have this inordinate amount of bleach. And I'm stopped by the police, and they open my bag and say, why have you got all of this? And I happen to be a young Muslim man from an area of South Leeds. I might well be closely questioned in those circumstances. The chances are that unless I can find a very good corroborated story, I might well be detained for a long period while they check whether certainly the police in London, and then they would go off to the police in DC, I guess, or maybe New York. They would check with the Pakistani police. They'd have to phone their friends in MI5 and see if they'll talk to them and tell them what they know. And that might all take 14 days. They're allowed up to 28 days, actually, because as well as that, they will also have raided my house. They will have stripped me of my clothes. They will be conducting all sorts of forensic tests. They will have taken all my computers. They'll be checking all my banking records. They'll have gone to my mobile phone. They'll have checked all my phone records. And if all of that is clear, I might be released. But all I can say is this is the most frequent charge, and when it is charged, it is generally sustained. The rate of conviction for all of these terrorist charges is quite high, is equivalent to the rate of conviction for normal crimes. Indeed, exceeds the rate of conviction for normal crimes, which doesn't entirely surprise me, because I think these are cases that have a lot of resources thrown at them. So that if they're going to prosecute, it is on the basis of some pretty exhaustive investigations over an extended period of police detention. So you find pretty good conviction rates, 80%, somewhere around there.
A typical sentence in those precursor convictions?
A typical
sentence, what, a couple of years?
No. It's gone up to, I would say, anywhere around 8 to 10 years. There are some cases which have been about the possession of information, documents, where a lighter sentence has been given, which I would describe anywhere between, I don't think I've ever seen any lighter than about 3 years. So they can be quite substantial offences.
Question?
Yeah, quick question. I'm an adjunct here at law school. I've got a couple of questions just trying to understand the big picture. Number one, you all draw a distinction, obviously, between acts that occur on foreign soil versus domestic soil, and planning takes place overseas. The British courts believe they have jurisdiction to reach that. Second, it seems to me that once you've got an overt act where some terrorist act has occurred, the court system is pretty well able to handle that after the fact. The key issue is beforehand, and it seems to me there may be a model in this country where you have a different standard. For example, there are a couple of Supreme Court cases, Parks and Dotterway, that allow you to impose criminal liability on someone strictly without showing mens rea because you're concerned about impact on public welfare and people are supposed to know that there might be regulation there. So maybe there could be different standards for terrorist acts because the potential for harm is so great. And then I'm a little confused about how the executive branch interacts with the judicial system. You have this obvious tension where you want to allow people to have due process, but at the same time, you don't want people to get so far down the road where you put more and more people at risk. And so how do you reconcile that? Anyway, those are a few issues.
Okay, well, I'll take two of those issues. I think some of them are probably more for Professor Chesney than myself. The issue of jurisdiction is an interesting one, and what's happened over time is that the statutory definitions, the statutory definitions of the offences have been extended to allow for all manner of extraterritorial jurisdiction, so that provided the evidence can be found, and provided, of course, we can find the person within the jurisdiction, and I again come back to the point that Britain probably doesn't have the facilities of the United States to kidnap people and render people in all sorts of underhand ways. We sometimes ask the Americans to do that for us, but it's probably going to be no use. I was describing to Professor Chesney earlier today a case, again before the House of Lords, 10 or 15 years ago, of an Irish person who was rendered unlawfully, I think, from Zimbabwe, and the House of Lords eventually took the view that this was based on complete illegality, and whilst this didn't taint any of the evidence in the case, they were not prepared to hear the case. You could say it brought the courts into disrepute to deal with this person, and the person was released. So I think that whilst we've extended jurisdiction, we do, of course, face the practical problems of having the person in the jurisdiction, and secondly, getting evidence from overseas which is not tainted by all these dreadful processes of coercive interrogation. And we know that, for one, the Pakistanis are not particularly angels in these matters, so we are very reluctant to take such evidence as given, and we have to really find the evidence for ourselves to be sure. So I think that's the main point. Your second point, sorry, could you?
There were two. The overlap between executive and judicial.
Yeah.
And when do you put it on one track and when does it come over? And two, whether there should be a different, and you were talking about a different standard, a lower threshold for terrorist acts, because the terrorist harm is so great.
Yeah, I think, of course, the different standard is this executive approach, which I described, which nowadays means these control orders, which can be imposed on a civil standard rather than a criminal standard. So clearly the burden of proof is still on the executive, but it is much lower than the criminal standard of proof, as well as being able to present some of the evidence, at least in secret, which helps their cause. What then about the courts giving them a hard time, you might say? Well, all I can say is that I can't think of any of these cases where a control order has effectively been lifted because of the intervention of the court, where it has then been shown that any of these people subject to a control order has then committed any crime. I would also add to that, which again I was talking to Professor Chesney earlier, that quite a number of people have been released from Guantanamo back to Britain. None of these have been subjected to any form of formal executive control, nor has any been proven to have committed any terrorism. So I think all we're doing is applying a degree of surveillance and assuming that they know, of course, that they've been identified at this point, and that their associates also know this point, and so they have been nullified by the fact of public identification in this way, plus a modicum of surveillance. And that seems to have worked. Maybe our concerns about risk are overdone at times, is one of my responses.
More questions? Sir?
How do the peculiarities of British surveillance laws kind of play into this sort of dynamic between executive and sort of criminal?
Right. Well, one very peculiarity is that we don't allow as admissible communications intercept evidence. You know about that?
Yes.
Yeah, right. This is in the law in 2000. This has been always the position for all sorts of historical reasons. And of course what this does is makes prosecution more difficult, because if you were in the United States or Canada or Australia, you would think about using intercept evidence as arose in, say, Zacharias Moussawi's case, let's say. And so it makes prosecution more difficult. This has been noted and was one of the major debates at the time of the passage of control orders in 2005. The opposition party, the Conservative Party, opposed the passage of control orders because they said, we can do more to achieve prosecutions, and they were in favour of the admissibility of intercept evidence. And this now has been the subject of a report called the Chilcot Report, which came out last year and said, in principle, the law ought to be changed, but there's a lot of details. The devil is in the detail, and we can't commit ourselves until we've looked at the detail.
Do you think the Tories will revise NEPA when they take power?
I think they will, yes. I think they will certainly be more favourably disposed towards changing this particular rule of admissibility of communications evidence, because they really did make a stand on this score in 2005 at the time of the passage of control orders. And I think there's a whole load of bunkum talked about this by the security services, a whole load of scare stories which, for reasons for their own convenience, they don't want to have to be put to the test. Yeah, there's a big accountability problem. So I think this is coming, and I think this will be a further boost to prosecutions. In other words, once they get used to the idea that this can be gathered for purposes other than pure intelligence purposes, they will begin to gather it in a way which is usable in court, and more prosecutions will come through which are sustained based on this evidence.
Doesn't that kind of complicate the overlap between executive and judicial, because a lot of the surveillance in the UK is carried out by executive warrants, isn't it? The Home Secretary.
All of it, virtually, yeah.
That's the only way to do it, right?
It is the only way to do it, yeah.
So doesn't that sort of give the executive a sort of run around?
I'm not sure that makes it inadmissible. I mean, the question is, there's a lot of countries in Europe which have executive-based systems. Even Germany, which has a very strong, I would say, constitutional regard for human rights in counterterrorism measures, allow intercept on the basis of executive orders. Now, I think the question is, whether the procedures have been followed, and what is the chain of evidence. Can you account for the way in which the evidence has been gathered and the transcript has been transcribed and so on? And I see no reason. I would prefer judicial warrants, but I see no reason why, even if you stick to executive warrants, this rules out the possibility of admissible evidence in court.
Let's get one or two more.
Yeah, I'm an undergraduate student of history here, and I was wondering, I know that in Northern Ireland, when the treatment of IRA men went from being regarded as political prisoners interned to criminal prosecution, the government had a big problem with hunger strikes and with protests. Do you think that today's shift towards criminal prosecution runs a similar risk?
Well, time will tell. I think there is one difference, I would say, an important difference, which is culturally based, which is, of course, the IRA, which was the main protagonist in the battle that you described between the government and those who've been imprisoned, provided a very disciplined organisation with a narrative and history and community support for a lot of what they were doing. And within the prisons themselves, you had a very substantial corpus of people who, equally within the internal processes of imprisonment, provided communal support in terms of narratives and strategies and discipline and so on. I think you need that to be successful in running a campaign of hunger strikes. It's a tremendously difficult process to mount hunger strikes as a political campaign. My supposition is that at the moment, at least, the people who are being imprisoned in Britain don't demonstrate those features. They don't have this kind of internal solidarity or discipline that the IRA had, nor certainly do they have the degree of communal support that the IRA had. I'm not saying there is no support, but it certainly isn't anywhere near the support of the IRA. So, you may find particular individuals who try to do this, but I think the situations are different for those reasons. And I think one other difference that I would draw is that, of course, the IRA moved from a situation where what was called their special category status. We Brits never called it political as such, but we used the term special category status. They had it, and then it was taken away. These fellows, what I would call the jihadis, let's call them, never were recognised as having special category status within prisons at any stage. So nothing has been taken away. And actually the kind of regimes that ordinary convicted prisoners have, particularly on long sentences such as these guys typically face, is much more relaxed than it would apply to IRA prisoners in the 1970s or 1980s. So in many respects the IRA have won these battles for everybody, and the regimes are now, I think, rather different from the regimes which applied in those terms. So, yeah, you may find hunger strikes coming along, although I don't see a tradition of hunger strikes amongst these prisoners in the same way as you can find, the Terence McSweeneys from 1920 it was, wasn't it? A long tradition of hunger strikes and prison resistance on the part of Republican prisoners fighting the dreadful Brits for a time immemorial. This does not apply to this group of prisoners.
We're pretty much at the end of our time. I just want to flag a few things by way of wrap-up. When we think about this from a U.S. perspective and what lessons you can or cannot draw here, we have to think about the things that one might argue might make us different or might not. We've had several themes running through here. I've noted that in a lot of the discussions, you know how different the politics of these issues are in the UK in terms of not being so clearly drawn as being a zero-sum partisan issue where one party's gain is going to be the other party's loss. I think our politics are a little bit more tangled up in a knot on these issues. The role of the judiciary and the extent to which there's going to be governance to the executive branch is something that both countries are simultaneously trying to work out. And in both cases, that actually seems quite similar. The direction seems to be in the direction of less deference to the executive than one used to see. But that is a lens through which we have to think about it as well on our end. And then finally, a big part of the discussion centered on the fact that these are home communities, neighbor terrorists. And one point that's often raised in discussions of the American experience versus other experiences, to a certain extent, the main thrust of the problem the U.S. is trying to grapple with is often described as being externally sourced in a way that wouldn't qualify for the neighbor terrorist label. And then one has to wonder if there's something about a policy decision that's key to the neighbor basis of it, the home basis of it. It doesn't translate well to our context. But notwithstanding those possible points of distinction, it's incredibly useful and insightful to hear about the UK perspective. In so many respects, it's all the same problems we're grappling with, and there's nothing but benefit to be had from hearing such a lucid explication of it. So thank you so much, and if anyone has further questions, which you no doubt do, please come up and see the professor after we break. Thank you very much.
Thank you.